know where you're up to so that we can make sure what we're talking about is exactly what you need. So I think that is now recording. Let me just get my screen ready for sharing. So I'll just wait to hear where you're up to. Oh yes, I see that you have you've put it in the chat box, made the decision and starting the conversation. And actually for these calls, it's absolutely fine for you not to have your camera on. Obviously you may want to be anonymous and that's perfectly fine, so no problem. Thinking about it, partner does not want to go ahead. Okay. Thank you for letting me know. So let me share my screen and we can begin. Hopefully you can see that okay. I'll keep an eye on the chat box, but while I'm talking, if you've got any questions that come up, feel free to put them in the chat box because actually I can come to them at the end and I can answer your questions. So it's a really good idea to just put down anything that's coming up for you while I'm talking. And if you've got any comments to share, so if you're in a position where you feel that something is resonating with you or you just need a bit more information, just let me know and I can help you out with that. So today we're talking about no-fault divorce, and some of you will know that this law change came in April 22. So at this point, we had been running with the previous way of getting divorced, which was actually mostly apportioning blame. Whether it was saying that the person's behavior was unreasonable, or whether you were saying that the other person had committed adultery, it was still about the person's behavior. And this changed in April 22, and it was a really big change actually to the law, and something that I think is really going to help people. So from that point of view, I think it's something that's really changed, that's right, that's going to help this process of divorce. Because actually, when you start off with apportioning blame, then it's already starting off in the wrong way. Often these divorce applications would go out and the other person would be upset with what was written. And that was never a good start to the process. So often we would start off with the argument around what was written, how, was it right? The other person may not feel that they want to proceed with a divorce on those grounds. Now that we have no-fault divorce, things are very different, and I'll take you through a little bit about what that means. But before I do that, I should introduce myself. If you have not been here before, if you've not come across me before, my name is Bhavna Radia. I am a former family lawyer. During my 20s, I qualified as a solicitor, and my specialist area has always been family law, even though I've done a little bit of immigration and a little bit of crime. It was a really good specialist area for me because I felt that I fitted the role really well, compassionate, empathetic, and really understood what my clients were going through. And I felt like I had a lot of skills in helping clients through that process in an easier way. Roll forward a few years, I got married and found myself in the same situation as yourself. So I'm now in that position where I am facing divorce proceedings just like you guys are. And it's a really difficult time. My children, and I have 3 daughters, were really young at the time. They were under 10 and my youngest was 1. So it was, very emotional, very difficult. I wasn't working at that time because I'd taken a period off work to bring up the children. And so I was really scared as well about the finances and what will happen to the children. And I'm sure, that you will understand how this feels. Whether you're about to have that conversation with your partner, or whether you've already had that conversation, you know that that decision is one of the hardest decisions you will make. And to try and get through that time is so difficult. Obviously, I did get through it, and luckily for me, I knew the law, I knew the process, so I was able to do things myself. But even then, it was really tough. And that did get me thinking that for those of you that don't have legal knowledge and you're going through this process, it must be really difficult. You know, it's a time when I was worrying so much, but I knew where I could take the process. I knew how to do things. So for people that don't know the process, don't really understand the legal aspect of this, it's a really difficult time. And that's why I changed the way that I work. I now work with people in a really different way, to make it more holistic, more empowering, and fixed. But I'll come to that a little bit at the end, just so that you understand how I work a little bit. But before we get to the work that I do, I want to take you through the no-fault divorce process. And as I said, it came into law in April 22, so it's been here for a while. Now there is only one ground for divorce, and that is that your marriage has broken down. You don't need to blame the other person. You don't need to let the court know what happened. There's no evidence or justification needed. Just a simple statement that your marriage has broken down is enough. As I said, I think it's a positive step in the right direction, even though lots of people say to me, but I wanted that opportunity to tell the court what went wrong, whose fault it was. And that is just not possible anymore. This new law has not made the process, it's not made the process quicker. It's actually made it slightly longer, and I'll take you through the timescales. So we don't have a quickie divorce now, which is what people thought would happen. The timeline is slightly longer. It's not easier to walk out on a marriage because now we don't need to blame the other person, because I'm sure you've agonized for many, many months, years even, before you make this decision. So what is no-fault divorce? You're here to find out a bit about what this process is like. And if you're just joining, feel free to put your questions, your comments in the chat box so I can come to them at the end. So now we have a situation where we can make a sole application or a joint application. And this was a new thing in 22, a joint application we'd never seen before. So with a sole application, it would be, for example, you on your own putting that application in, and saying that your marriage is broken down. You would be called the applicant if you're starting the divorce application, and the other person is called the respondent because they are responding to the application. If you're both in agreement to the divorce, if you've had a chat and you've both decided this is the right thing to do, then it makes absolute sense to start a joint application. That way you're both in control of the process. One person doesn't feel like everything's against them. So it can be a really good way of starting. And I do this a lot with clients that are saying that we're both in agreement, we want this to go ahead. And both of you get to fill in the form. So you both feel like you're involved. With a joint application, you're both in control of the process. So it's quite a good thing where one person doesn't want to be on the back foot. Both of you want to be the driving force for this process. But a joint application is not for everyone. So you need to think about whether it's the right step for you. If there's been domestic abuse, it may not be the right step for you to apply together. And it might be better for you to make a sole application. And the reason why that is because you need to communicate with the other person. And it may not be possible for you to have that communication if you are intimidated by that person, if you have a non-molestation injunction against them, and you're not, he or she can't communicate with you. So there's various reasons why, if there's been domestic abuse, it may not be the right step for you. And also, if you want to stay in control of your divorce, you might want to apply solely rather than jointly. And I'll come to that a little bit later as well, just to let you know how you can stay in control of the divorce process, because that might be important to you, especially if you think the other person is going to make things difficult. So bear that in mind as well. There's not many options to defend a divorce now, so we won't see that very much. So the other person can't say, no, I'm not going to let you go ahead with the divorce process. And I know that one of you did mention that your ex-husband or wife doesn't want you to go ahead and will stop you. So just to let you know, there's not many options to stop you. The only options that you have now is that the marriage was never valid, or that the other person is not of sound mind. So there's not much option, or that the divorce has already happened in another jurisdiction. So then the court obviously can't go forward with divorce proceedings in the UK, in England and Wales. So if you are in a situation where you have put in a sole application and you find that the other person is not happy to proceed, I'll take you through the steps that you need to go through. But before I do that, you need to know that you can do this process on your own. The courts have made it much easier for you to apply yourself. It is an online application. You can do a paper application, but the online application is much simpler and obviously much easier to submit because you submit that online. The questions that you get asked in the application, again, are much easier to understand. So it is something that you can go through yourself. A solicitor will charge you between, say, $1,200 to $1,500 to do this for you, but it is possible for you to do it yourself. So regardless of what happens with whether you're going for a sole application or a joint application, this is the time frame that you have to go through. When you make your application yourself or using a solicitor, the court will have a look at your application and make sure that everything is correct. If they are happy with everything that you've written on there and everything is correct, they will then issue the application. And when that application gets issued, what happens with a sole application is the other person gets notified about your divorce application. Obviously, if you've made a joint application, the court knows that you're both aware because you've both signed to say that you want that application to go ahead. But with a sole application, the court will issue it and send it to the other person. And you will get an email to say that this has now been issued, the other person has received it. From that date, you have a 20-week minimum time frame that you have to wait to get to the next stage. The next stage is conditional order. And with a conditional order, you will get an email. The court will say you can now apply for conditional order after 20 weeks. And what you are saying is that you've met all the conditions to get divorced, that your marriage has broken down, that they've seen your marriage certificate, you've waited the 20-week minimum, and the other person is aware of the application as well. So you've got to meet all those conditions to be able to apply for a conditional order. Once you apply for the conditional order, you'll get a certificate saying that you've got your conditional order. So that at that point, you are not divorced. You have just got the first order in respect of your divorce. To actually get divorced, you have to wait another 6 weeks and then apply for final order. So when you get your final order, this document that you'll receive is what you would use to let organizations know that you're divorced. That is when your marriage has come to an end officially. So that's a basic level of the process. So from the issue of the application to final order, the minimum time frame is 26 weeks. So that's the earliest that things can happen. What happens in between is when the court issues the application to the other person, if it's a sole application, has to fill in a form to say they have received it. They'll receive that by post, they'll receive it by email as well. If they don't fill in that form, then they can make it hard for you to carry on. And I know, as I said, one of you said that your husband or wife may try and stop you. What you will need to do if they do not fill in that form is to prove to the court that they have received it. And there's many ways of doing this. If they refuse to fill in the form, you can get the court bailiff to serve them with the application, or you could get a process server to serve them with the application. So somebody will go around and hand this application to them, let them know it's a divorce application, and then they will give you a report to say that they've received it, and you can then continue. The other option is if your husband or wife has said, I've received your divorce application and I'm not filling in the form, then you've got evidence they've received it, and you can make an application to ask the court to allow you to proceed. There's many ways of actually getting around your husband or wife not filling in that form. So you could have alternate service, which is the process server going round. You could say that they have definitely received it because you've got the evidence of it. And the other way of doing it, if they've not messaged you or there's no evidence of them receiving it, is asking the court to make an order that you can send it to them by WhatsApp or email. And that means that the document is served on them. So there's lots of ways around it. Don't feel that you can be stopped going forward if you want to get divorced from your ex-husband or wife. So if you are able to show the court that the other person has received it, then your conditional order will just continue as within that 20-week minimum period. So at least you know that your ex-husband or wife trying to stop you will not delay the process, at least. If you've made a joint application, then you don't need to prove the other person has received it, and the process just carries on. So the court will issue the application. You can apply for conditional order and you can apply for final order. There's no need to prove service. The difference with a joint application is that both of you can apply for conditional order and both of you can apply for final order. So because it's a joint application, both of you are in control of the process. With a sole application, it's the person that has applied initially that can apply for conditional order, and they can apply for final order within 6 weeks. So if you're the one starting the divorce process on a sole application, the other person can't apply for conditional order or final order straight away. Final order they can apply for later on if you don't apply for it. So it still keeps you in the driving seat with a sole application. And I do say to a lot of my clients where they're not sure what will happen, how their husband or wife will feel, to make a sole application so they're more in control. And I hope that makes sense. There's quite a lot of detail there, but it's important for you to understand which application to go for. So that's a little bit about the time frame for the divorce process and how it actually works and the different stages. But lots of people will ask, well, how does it work with finance and children? Because we've got assets to share, we've got children together, what happens? So I'll take you through a little bit about that. And the situation around finances and children hasn't changed. Since the new no-fault law came in, the finance process and the plan for the children, that hasn't changed. So if you've got any property, if you've got money, pensions, ISAs, anything like that, you still have to follow a process to work out how you will share that. First, you have to declare everything to each other. So everything in your name that is in the UK or abroad, and your husband or wife should do the same. And you should put down anything in joint names as well. This then gives you a picture of what you both have. So even liabilities should be declared as well. So any debts that you've got in your name, any loans, anywhere that you owe money back has to be declared as well. And this then gives you a full picture of everything that you own and everything that you owe. And once we've got that information, only then can we start looking at the fairest way of splitting everything. How do we share what there is? And the hope is obviously that you come to an agreement on that. You discuss it, you look at what both of you need, if you've got children, what they need, and you come to an agreement. And if you can come to an agreement, then you would file a document called a financial consent order at court, and it outlines your current situation and it outlines what you've agreed as well. It can be called a clean break order. Some people call it a financial order or a consent order. It's all the same thing. It's a financial consent order. And a consent order means that you've come to it voluntarily. It's an agreement around your finances only. This document, once you've reached an agreement and you've got this document prepared, it can only be sent to the court after conditional order. So you have to show the court that you've, and I'll just go back to the next slide so you can see, you have to show the court that you've met all the conditions to get divorced. And then once you have that certificate of conditional order, that's the time that you can file your financial order at court. With this 20-week minimum, it doesn't mean that you have to apply for conditional order straight away. You could apply in 30 weeks. And your financial order may not be ready straight after conditional order, and that's okay as well. You can file it at any time after your conditional order. You don't have to apply for final order in 6 weeks. You can apply for that in 10 weeks, 20 weeks. It doesn't have to be straight away. So if your financial agreement is taking time, you get to conditional order, you've got your conditional order, and your financial order isn't quite ready, then that's okay. Don't stress. You can file that even, a few weeks after your conditional order, a few months after your conditional order. So I hope that makes sense. Once you have filed your consent order with the court, a judge will look at the documents and they will assess whether your agreement is fair in the circumstances, because fairness is different for every situation. Some people would say 50-50 is fair, but it isn't always fair in every circumstance. So you have to bear in mind that the agreement has to be fair, based on needs, and a judge will look at that. And if they think that, yes, this is a fair agreement based on your circumstances, then that document will be turned into a court order and it will be sent back to you. So now whatever you've agreed around your finances is legally binding on both of you, and it is a court order as well. Once you've done that, then you would apply for your final order. So that's how the process would work if you have finances to share. Lots of people ask, is a consent order even necessary? We've reached an agreement. We've sold the family home as we agreed. We've split the proceeds. There's nothing else to sort out. I'm keeping my savings. I'm keeping my pension, and so is the other person. Why do we need this order? It's really important to get a consent order done. And the reason why is because before then your agreement could be changed. Even though you've sold the house, the other person may say, well, that agreement wasn't fair, and take you to court because you have not finalized things properly. So really important to get this consent order. It protects you, it protects the other person. They can never claim on you again. You can never claim on them again. So really important to think about getting a consent order. But what happens if you can't get to an agreement? And lots of people do have this issue. But if that's the case, if you have tried everything to get to an agreement, and sometimes it's just not possible, you're both just thinking about this very differently. You might want to keep the family home, the other person might want to sell it. As an example, what would you do? And it may be that if you've tried every other out-of-court dispute resolution option, such as mediation, there's new things like finance neutral, lots of other ways of trying to get to an agreement. If you have tried them all and you just can't get there, what will you do? The next step really is court proceedings if you have tried everything else. And important to try everything, because court proceedings are long, they're really stressful, they're really costly. It's really a last resort. So please try everything else first. Just because we don't want you spending so much money on legal fees. When you go through court proceedings, your legal fees could be 50,000 each. It's not always that high, it could be 20,000 each. But once you're in that process, it's very hard to gauge how quickly things will get resolved. And most people will find that you have less money to share, not more. And the judge will make a decision based on what he or she thinks is fair. And it may not be what you're happy with. So sometimes it's better to try and get to an agreement rather than go to court. But why would you go to court? Your husband or wife won't disclose their assets. They will not tell you what they've got in their name. You might believe that they're hiding assets. And if that's the case, and they will, they've hidden things and you can't get to the bottom of it, then court process might help. Doesn't always help, but it might help. They might be selling assets without your knowledge or your agreement. They may have put, say, a rental property that's in their name on the market, and you can't stop them. They will not stop that process of selling this property that is part of your marital pot. You can ask the court to stop that sale until matters are decided. Or it might be that you've disclosed all the assets, there's no hidden assets, but you just can't reach an agreement and you have tried everything else to try and get to an agreement. Then maybe court proceedings will be the only option. During the court proceedings, and court proceedings are quite lengthy and complex, but during the court proceedings, the court will encourage you to try and get to an agreement, whether it is outside of court, whether it is go back to mediation. They may encourage other ways of trying to get to an agreement. But the point of the court proceedings is trying to get you to agree. And at some point, if you still haven't managed to get to an agreement, you will go to a final hearing, and that's when the judge will make a decision for you based on your circumstances. And once the judge has made that order, it's legally binding on you. You can't change it. So that's a little bit of the process on the finances. And I will be doing some talks in the next few weeks around the family home and how to work out whether your financial settlement is fair, because fairness is different for each person. So it's important to know how the courts look at fairness. The other aspect of the divorce process is the plan for any children. And it's such a worrying time. You worry about what's going to happen to the children. And it might be that if you've been the main carer, you find it hard to let them go. You don't want the children to leave and maybe spend a weekend away from you. Maybe you've never been away from your children, and so it's a really difficult thought. The thing with the arrangements for the children, it is important for them to have good quality time with both parents. It's good for them mentally, it's good for them socially, emotionally, in every way, that they have good quality time with both parents. But when it comes to the children, the court doesn't like to get involved straight away. They assume during the court process that as parents, you will make arrangements between you that are in the best interests of your children. So during this legal process, there's nothing that you have to do from a legal point of view around your children. Obviously, you need to reach agreement about possibly how the arrangements will work. The court doesn't really like to use the words custody and contact so much. They now use arrangements. There is a presumption that you will have shared arrangement. So it could be that the children spend equal amounts of time with both of you. It may be that because of work pressures, the children need to spend a bit more time with one parent and slightly less with the other just because of work. So if you're doing a shift work, you're working nights, it might be that you can't have the children overnight as much as you would like, possibly. So it's a good idea to reach an agreement around the plan for children, and the court will assume that you can do that. If you can't do that, then you can always go to court for a judge to make decisions for you. But just so you know the law, both of you have the same rights and responsibilities around the children. As parents, you can come to an agreement about how much time you both spend with them. It doesn't need to be written down. It can be just something that you verbally discussed and put in practice. So when I separated 13 years ago, we didn't write anything down. We had an agreement. The children were quite young, and my ex-husband had them in little spurts because he'd not had them for on his own, all three of them. And it is quite a lot to manage if you've not had them on your own before. So he had them, say, for a couple of hours to start with, and we built that up slowly. And then it was every other weekend, which is what he wanted, and a couple of weeks during holiday, summer holiday. But that was what our agreement was. That's what he wanted. And we just followed that through. We didn't actually put it in writing. And then as the children got older, that turned into every other weekend and half the holidays. And that agreement has continued. So we still don't have it in writing, but we know what our agreement is, and we know the weekends that where the children will be and the holidays as well. So it's a good idea to put it in writing though, because then you've got a baseline for what your arrangement is. You have got, you can add in some flexibility. You could put down what happens when there's a family wedding, what will we do? So there's lots of different things that you can put into an agreement. The agreement can be written by you. You don't need a lawyer to do it for you because it's not being sent to court. It's just a document that you both will be using to manage and navigate through the arrangements for the children. If you can't reach an agreement, and sometimes that happens, then again, try and use mediation, other out-of-court dispute resolution options first. You don't want to rush to court if you can help it. Sometimes family and friends can act as mediators to help you as well. But, if you can't, then obviously the court process is there to help you get to an agreement. So nothing has changed around the child arrangements. This joint application that you can now do under the no fault law will mean that less couples will go to court. And that's actually what's been shown, is that more couples have been able to stay amicable, which means that your legal costs are reduced. I do a talk around children as well. So, if that is a specific area that is something you need help with, then feel free to come along to that talk as well. Legal costs is always an issue around this because your average legal costs in the UK is 18,000 each. And that is quite high when you think about you're already splitting one household into two, and that might be a strain already. And then with legal costs adding up, you are using up all your available funds on spending money on lawyers. And so obviously that is something that you need to think about through this process. And I'd be really interested to know how, if you could put it in the chat box, how do you think you will navigate this process? Do you think you would want to do it yourself? Do you think that you'll go straight to a solicitor to get it done for you? How do you think best for you to navigate this? Just so you know, solicitors charge on an hourly rate, usually around £350 per hour, and then VAT on top of that, which makes it around £420, £450 an hour. Very quickly after your first meeting, the first letter that comes out to you will cost you around £1,000. So it does add up. Through this process, solicitors are encouraged not to make things hostile, to be collaborative and cooperative. But in theory, that doesn't always happen. There are really good solicitors out there that make sure that it does happen. But there are also many, many solicitors that are there for the hourly rate because obviously they are making money and they will encourage hostility because their fees go up. But the other thing is sometimes solicitors can be really aggressive, and that really doesn't help either of you because your costs will skyrocket. And what we want is this process to be as amicable as it can be, and it's not amicable for everyone, but amicable and easy as it can be. low cost as much as possible so that you can keep your money in your pocket, which you will need when you're getting divorced. Costs are also dependent on the other person's behavior. Even if you behave well, if the other person makes this difficult, if the other person puts obstacles in the way, will not disclose assets, will fight you for everything, then obviously costs go up. If you're both able to communicate, cooperate with each other, be reasonable, then your costs can remain really low. So it's really important to think about how that could work. And obviously you can't control the other person, but the way you communicate, maybe you could control that to make it easier. So that's a little bit about costs as well. And feel free to put your questions in the chat box about anything that I've talked about already. If you've got any questions about starting the process, how it might work for you, let me know and I can come to that at the end. But what I will tell you about while you're thinking about any questions you've got, and I can see there's already a few there in my direct messages, is the way that I work. I have a fixed fee service, and it is a service that helps you manage your divorce yourself, but not on your own. Because a lot of people are worried about managing their own divorce because you don't know the answers. It's really hard for you to know how to do this. There's so much information out there, but it's quite confusing. And some of you will have already noticed that it's really difficult to apply it to yourself and understand which parts you need to think about, how you apply it, how it works in practice as well. What I do is encourage you to do it yourself. So we keep your costs right down, but I am there for 6 months supporting and guiding you. So if you've got a form to complete, I tell you what form it is. I send it to you, you complete it with some guidance, and then I check it for you to make sure it's all correct. So you don't make mistakes. You're not worried about your legal rights and making sure that you understand everything, because I will explain it all to you as you're going along. We're talking about finances in a lot of detail. I'm showing you the different things that you can do around your finances. So you do become financially empowered. You understand the process a bit more. You're confident, you're emotionally resilient because you have got a community with you going through this process. And we are looking at what your vision is for the future as well, because we have to hold on to that. When you're going through a divorce process, your vision for where you're going is really important. And I support and guide you, and I'm there every step of the way through this support program. So what is included? It's 6 months of support and guidance. The first thing we do is a one-to-one call to plan for how your divorce process is going to be, because it's important we do this the way that you need it. And for some people, they need to get prepared. They need to get their emotions in order. They need to do some research on the finances. We have a plan for going forward. And we put that plan in place, and then I give you action steps to take to make sure that happens. We have a one-to-one call to plan for your finances, because once you've got all the financial information, we need to come up with some financial proposals that are fair, that are reasonable, that are viable, we know that could work. And you get to choose. If we've come up with 4 proposals, you choose which one works for you. I'll take you through the benefits and disadvantages of each one, and we decide where we are going to start that negotiation from, and what's the top level for that negotiation. So you're always aware of what you should be negotiating around. There are 3 weekly live calls that you can join. So every week you can touch base with me. Every week I'm able to move you forward with actions, with checking information, checking communication, correspondence. We have anytime messaging support as well, so you can drop me a message outside of the live calls. And I give you resources and templates and information as you're going along, so that you always know your next step and you always know what to do and how to do it. You can stay longer than 6 months if you need to. There are clients that finish the process in 6 months, or at least have done most of it in 6 months. But if you need to stay on longer, then you can stay on a month-to-month basis, so that I can keep supporting you if that's necessary. You don't necessarily need a solicitor through this process, which people think you do, but actually a lot of people now are doing it themselves just because of the high cost involved, and they want to stay in control of the process as well. And I'll just talk you through how it worked for a client of mine who was in the program with me. I've called her Maya. Obviously, that's not her real name. But so what Maya did was we sat down together, we worked out this best plan based on her priorities and based on her circumstances and what she was worried about. Once we'd done that, we started moving forward with things. We started her divorce application first because she knew that it took a minimum of 5 months to conditional order. And that was the first thing she wanted to do. So we put that in place first. We worked on financial clarity because that's really important for you to understand the finances. And until you work on that, sometimes it's not always clear how much you've got, how it could be shared. We made sure that we had transparency around the finances, and we put together 5-6 proposals that could work for her. I have a financial expert who helped also with proposals to make sure products were available, and that actually the way we'd put the proposal together worked from a financial product and financial advice point of view. Because they didn't want to wait to submit the consent order at the date that it needed to be, the earliest it could be submitted, we put a separation agreement in place. So it's like a holding agreement. And they were able to transfer the house into one person's name. A lump sum was paid to the other person. And then when it was the right time, the financial consent order was submitted to the court, and then they obtained final order. So that's the way the process worked for them. I was working with Maya through my program, so I was able to help her every step of the way to get through this and understand when things needed to happen, and to find creative solutions as well to make things happen the way they wanted it to. So that's a bit of detail about how I worked with Maya. And feel free to reach out to me if you think the Divorce Right program would be right for you, if that is something that you are considering. The fixed fee for 6 months is £2,500, which can be paid in installments over 5 months. And lots of my clients get through the process, and obviously they're not paying £18,000 each, because with me, they're keeping their costs fixed and quite low. So if you think that you would want to know more about how this could work for you, then feel free to drop me a message or to book a call on into my diary, and Nelma will put a link where you can book that call if you think it's the right thing for you, and you'd like to know more about the process. I have a book which is, again, all about you taking action, because that is really what I ask my clients to do, is to take action. I want you to save money. I want you to reduce stress and get the best outcome. And that's what the planner is there to do. It's to take you through the legal process. Actually, you filling in the information in the book as well. So it's got worksheets in there for you to actually start bringing together the information that you need to get through this process. So you can purchase that from Amazon. And again, Nelma will put that link in the chat box. And we have something special running in September. And this is a mini course. It's called How to Break Free in 4 Days. And through the 4 days, I go through each step in a bit more detail. So we talk about the divorce process. So again, talking about similar things to today, but going a bit deeper. Day 2 is all about your financial clarity and asset settlement. How are you going to do this? How do you get clarity? What does it mean? What steps do you need to take? Day 3 is all about creating a plan for your children. we actually look at the detail around this, and I'll give you resources so you could start thinking about how to come to that plan. And day 4 is about your support system. Really important to have people in your corner. And who could those people be? So we talk about that. Each day is about 45 minutes. I answer questions, give you resources, a task to do so you can move things forward for yourself. This is actually a free mini course. It's being delivered live from the 16th to the 19th of September at 9:30. And again, it's on Zoom, so feel free to join. You can be anonymous as you have been today. And it's a free course. The value is priceless, but it's free for you to attend. And actually, there's quite a lot of learning that can come from that. So feel free to click on the link that Nelma's put in the chat box to join that event. You'll be sent details of the Zoom link. You'll be sent details of what I'll be covering every day. And once you've registered, if you can't make a session, then don't worry, a replay will be sent out to you. So feel free to join that on the 16th to the 19th of September. And that is actually coinciding with 13 years from the date that I made the decision to get divorced. So it's my way of paying it forward. Obviously, I'm 13 years ahead of you, and I'll be talking a little bit more about my journey and where I am now, so that you can see that there is hope. There is so much to do to get through this process, but once you're through, that there's a lot of joy and peace that is waiting for you. So I timed it to fit an important milestone and for me to remember that important milestone as well. So I hope you can join me there, which will be, it's going to be an incredible 4 days for me as well. But feel free to connect with me on socials, on my website. There's some free guides there. There's lots of tips and information that I share. So it'd be lovely to have you join me on the sessions in September, but also come and follow me on socials and on my YouTube channel, where I am providing information and tips as well. And I'm sure Nelma will put these details on the chat box as well and the YouTube channel as well. So I'm going to stop sharing now and look at your questions. Let's see what you guys have been asking so that I can go through and answer any questions you've got. So I've got a direct message. We are both mid-50s, and he keeps saying in front of the kids, why at this age, as normally people just stay put at old age? Well, you're definitely not old at 50. But I would rather have another 20 or so years of quality life, as the kids will soon make their own life and move on. Absolutely. My children are now 22, 19, and 14, and they already have their own lives. And so I'm pleased that I've had 13 years of being out of the marriage, and I can say that life has definitely been good for me. So you're not too young to take steps, and sometimes it doesn't matter your age. It's difficult to stay in a marriage that's not working, but it has to be the right step for you. That's important. You have to make the decision that is right for you. And obviously for some people it is right to stay even though they're still young, they're mid-50s. That's the right step for them, even though the marriage isn't working. So I've got a direct message. Can I get legal aid if I'm a victim of domestic violence? I am a working professional, so I do earn, but I don't have any savings from the day I separated. So am I eligible for legal aid? So legal aid is dependent on your income and your capital. So it will be dependent on how much you earn and the savings that you have. And you say you haven't got savings. So it will be dependent on how much you earn. And you need to speak to a legal aid lawyer to find out your eligibility. But you also need to have reported the domestic abuse to an independent third party, like your GP, the police, a domestic abuse charity. That's really important. They will ask for evidence of that. So that's how to be eligible for legal aid. if you go to the Law Society website, there's a section called Find a Solicitor, and there you can search for a solicitor in your area that does family law and legal aid. There's not so many legal aid lawyers now, and I actually used to do legal aid work before. And so it's quite hard to find a lawyer that has capacity to take you on, but it's definitely worth trying to see if you're eligible and see if you can find a lawyer that has capacity. Another direct message, another point which holds me back is the kids. They keep saying you are both getting old and need each other in old age. But I know people even at 60 getting divorced. At least they have quality life going ahead, maybe alone or with someone else. And yeah, I mean, it's dependent on how you feel. The children will move on. They will leave and live their lives, and then it will be the two of you together. And you have to, the way I made the decision when I was going through it, I thought about what my life would be like in 1 year, 5 years, and 10 years. And I really couldn't see any improvement. And I could see that it would be a very difficult life for me. And that's what prompted me to make that decision, that in 10 years' time, I can see myself still upset, still in this same place. And do I want to face this in 10 years? No, I'm ready to do it now. So that was how I looked at it. But it's got to be, so it's such a personal thing. It's got to be right for you. Should you do the child arrangements and financial settlement before initiating a divorce, or is it advisable to do it in parallel to expedite the process? So there's no right or wrong answer. You can't submit the financial order to the court without divorce proceedings. Some people will decide that they're separating and divorcing, but they will reach an agreement around the children. So what's going to happen with the children when you separate, when you're not living together anymore? How are you going to split the finances when you separate and get divorced as well? And so it's fine to reach an agreement around the children. It's fine to reach a financial agreement as well, and then start divorce proceedings. But you will have to wait 5 months before, slightly more than 5 months before you can submit that financial consent order to the court. And I did have a client that did it that way, which is absolutely fine. You can do it that way. You've got to do it in the way that you think best. But one of my clients wanted to do it that way. She got to an agreement on her finances and didn't want to start divorce proceedings straight away, so waited on that, and he didn't want to put anything in writing, so no holding agreement. And then by the time we got to sorting out the financial consent order, he had changed his mind, and actually money had been moving around and things got very, very difficult. And they ended up in court because she knew he had the money, but later on it had disappeared. So yeah, just be careful how you do it. It depends on the psychology and the personality of the other person. How much compensation for domestic violence and verbal abuse can I ask my husband in an out of court settlement? It's 7 years of marriage with police involved in the end. So there is no such thing as compensation for domestic violence and verbal abuse. When you are settling your finances, there are certain things that are taken into account. One of them can be bad behavior, but there's no fixed sum for it. Bad behavior in finances usually is to do with when that person their bad behavior has caused you to have less assets, or say there's an alcoholic who hasn't been to work. Maybe the other person is a gambler and they've lost a lot of the financial assets for the family. So that sort of bad behavior is taken into account. But even then, we can't always monetize it. So you wouldn't necessarily get anything, compensation for domestic violence or verbal abuse. So I hope that helps. I know it's probably not the answer that you're looking for. Can a court in England make a decision on joint property abroad? Really interesting question. And they can make a decision on joint property abroad. Even though the property is outside of jurisdiction, they can say that this property will stay with this person and this property will stay with that person. So yes, they can make orders relating to everything. Can financial orders be legalized by a solicitor, or does it need to be sent to the court? Are you able to help with it? So a financial order has to be sent to court to be turned into a court order. It's not enough to have a financial consent order that a solicitor signs or a solicitor prepares. That doesn't make a difference. It has to go to the court. So even if a solicitor prepares it for you, it will be sent to the court to turn it into a binding order. You don't have to have a solicitor prepare it for you, even though it is a very complex document and you don't want to get it wrong. The courts don't say that a solicitor has to prepare it and a solicitor has to sign it off. It's just it has to be written in the right form. And there's many ways of getting that done for you or done yourself. So with my clients, I provide them with an example of these documents so they can see what they look like, what it contains. And for some clients, it's possible for them to amend my example consent order, and it works perfectly fine for them, as long as their process is not, their agreement is not so complicated. Where you have a complicated situation, it may be that they're not able to amend it themselves, even with my help. Because it would take me so much time to do that. Sometimes it's actually easier to use another provider that doesn't charge too much. A solicitor will charge you about £2,500 to £3,000 for a consent order. There are organisations that can do it for £400. And because you're working with me, I would make sure that that document is correct and is right for the agreement you've reached. So important that you look at that and see how you can save money doing it, but it's done properly. Really important that it is done properly for you. So I hope that helps. I'll take that as my last question, just because of time. I know we've been on for an hour. So I hope that's been helpful. Do let me know your thoughts. How did you find this talk today? I know that it is a little bit complicated with the different processes involved in starting an application, but I hope that it's helping. I hope that today answered some of your questions as well, which is the important thing, where we need you to be knowledgeable and feel empowered to take steps. So thank you for your messages and your direct messages as well. Feel free to add a few more messages if it's been useful today. Come along to the event in September, and if you can't make it live, then register and we'll send you out replays and the templates that we'll be giving out during those sessions. So it'd be really good to have you there. Feel free to come along, and yeah, it would be great to answer your questions and to help you along the way. And to actually mark a milestone in my life, which is 13 years since I made that decision as well. So would really appreciate you attending, and I look forward to it. Also, we are looking at, I can't remember what the session is next week. Nelma, maybe you remember what next week's session is about. Is it about pensions? I think it might be. Maybe put it in the chat box, just so that we know what's coming next week. I think it's about pensions. Yes, pensions and divorce. Pensions is a really important one because a lot of people ignore their pensions, and it can leave you in a difficult financial position. So it's a boring subject, I do get. It's quite complicated, but a really important one. So I look forward to catching up with you there. And do touch base if you would like to know more about the programme and how it might help. Lovely to see you all, and do take care. See you soon. Bye-bye.